Hello and a very warm welcome to everybody. I am Shrija Agrawal and you are watching Deal Street. In the next 25-30 minutes today in this episode, we are going to discuss essentially what happens to all of us in life. Imagine going in a certain direction and then something unprecedented or unexpected happens and all your plans come crashing. This is exactly what happened a few days back when the Supreme Court squashed the RBI Feb 12 circular. Now it becomes really important to understand the importance of that circular and what it really meant for lenders. That circular essentially envisaged a new framework of resolution of stressed assets and replaced the erstwhile arrangements like CDR, which is corporate debt restructuring, SDR, strategic debt restructuring, S4A, and GLF. Now, with the Supreme Court squashing the Feb 12 circular, it's actually opened a Pandora's box of questions. Does this really mean that we are going back in time and getting those erstwhile debt restructuring mechanisms back in vogue? And also, what does it really mean for the ongoing cases? Can these promoters really claim their companies are in NCLT? To talk about more on this, I have with me two very interesting guests today who actually do this in their daily lives. With me is Ravi Chachra, who's the Chairman and Chief Investment Officer at Distressed Fund 8 Capital. And I also have with me Nishant Singh, who's a partner at Indus Law, specializing in M&A transaction and specialized assets. Thank you, gentlemen. Thank you for talking to us today. Let me sort of begin with you, Ravi. What exactly does this really mean?
First of all, I think that the companies that have not already gone into NCLT with the lenders, they don't have to put it in now. They can find another solution. And they have a few things that they can do, right? So they can use Project Shashat, which allows them to do a restructuring with just 65% of the committee of creditors or joint lenders forum, because that's probably back now. And second is they can always, if it is provisioned to a point where the fair value is there, they can sell the loans to any asset reconstruction company. And finally, they can still go to the NCLT. It's their choice if they want to do so.
So what happens to the IBC and the entire NCLT process? I want to understand from you what are the kind of panic voices or the sanity voices, if you will, that you're hearing from them.
The goal of the IBC was to get quick resolutions. Supreme Court has weighed in some of the past few cases and said it is not just about quick resolutions, it is also about value maximization. So this kind of moves it towards that needle as well. So if you think about it, who went to protest against the February 12th circular? The power producers.
Yeah.
Now, why did they do that? Now, many of these power companies are white elephants, right?
True.
So there may be a gas power plant with no gas, right? There may be a thermal power company, a producer, which has no coal linkage, or they may not have a power purchase agreement. So you have spent billions of dollars and you have borrowed or thousands of crores, and you have borrowed at very high interest rates from the public sector lenders. And you're not able to produce any power or sell it, even if you produce it, to repay these loans. And at the end of the day, the lenders are saying that the value that you're going to get in IBC will be so low.
True.
That it doesn't make any sense for us to take it into the NCLT process.
I come to you now, Nishant. Whenever sort of I've spoken to, large corporates or the private equity investors, like Ravi, IBC has really been hailed as a very deep transformational reform, right? Which will go down the corporate history as something which has never been done before, was unprecedented. Now with, what has Supreme Court done, one would really want to understand that what really was the intention to do something like this?
The Reserve Bank of India obviously is the regulator in the Indian banking market and needs to actually look at if the NPA levels are going at a level where it becomes a systemic risk, does it have to intervene and tell the bank in what way they need to resolve the NPA accounts. Now, there are policy guidelines which are issued by Reserve Bank of India and they're absolutely kosher. As far as the Feb 12 circular is concerned, Reserve Bank of India came out with a general framework saying that if anything is above 2,000 1,000 crore, there's a delay. You have only 180 days, the countdown begins, and if you are not able to resolve within that time, then you will have to necessarily knock on the door of NCLT under IBC. So definitely, from a regulatory perspective, it tried to tackle everything in a one shot by creating a system, and it injected a kind of deterrence in the minds of the promoter as well, who were on the default that there's a fear of losing asset, FOLA. And in many cases, we were seeing, because of Feb 12 circular last year when it came out, many promoters who were actually on the precipice of default, they started actively looking at, with the lenders, a prepack solution, right? And some of the prepack amendments are actually on their way to figure out how resolution can be done better under IBC. So the whole issue is, for any lender, what is the best resolution process?
When you're saying a specific default, you have to deal with it specifically, that's subject to discretion by various parties, right?
That is the power.
It's again
of
kind of going back, because you had IBC, which was clear. It was like extremely clear that there's a certain direction that we have to go to. And right now you're saying that RBI can nudge the banks to take them to NCLT, but it's specifically. So what does that really mean in simple English then?
Simply, English is simply means RBI is a regulator. As a regulator, you can intervene in the business of banking by telling the bank that you have to only resolve it in a particular way. Should you find that this is becoming a really big issue and it must be resolved only in a particular way, that is the IBC.
So the way I read it
could be resolutions outside IBC as well. All Supreme Court is saying is RBI has the power.
So I think the couple of things that the way I look at it, the most important aspect that has made the promoters or the existing sponsors go and fix their companies or the balance sheets is Section 29A, which doesn't allow a defaulting promoter to go bid for the company again. And that is still there. And I think as long as that is there, and the threat of IBC that the lenders still have on these companies by taking them through NCLT, I don't think really the game has changed that much. Now, it's up to the lenders, and the other big thing, why are we here? The reason is the banks have to recognize these bad loans. Then once they recognize it, they have to provision for them.
Yeah.
And when you provision for them, your balance sheet gets hit, your book values are hit, and you have to raise more equity capital or equity-like capital to fill up your coffers again to pay for these bad loans. And where will this money come from? If the banks are owned by the government has to pay for it.
So you're saying the fear still exists of losing the asset, because
Absolutely.
29 years still holds valid,
Yes,
right?
yes.
So now tell me one thing, I want to flip the question now, that Ravi, what does it mean for investors like you?
From our perspective, we have been kind of not that excited about NCLT because we have tried bidding in it. It's kind of choked. There is a jurisprudence is getting created. That means it's a new law. People are testing it, especially deep-pocketed promoters and other vested interests. They could be any stakeholder, if you will. So we have been looking to do other things with it, including checking out Project Shashank, etc. And we recently, and we think acquiring loans, paper on the way down, from lenders and then taking over the resolution process is a better way to go. And then as an owner of the loans, we can decide whether I want to do an out-of-court restructuring or whether I want to take it through bankruptcy. And this allows us a second bite at the apple because the lenders now have a time frame that is not chopped at 180 days for us to continue the negotiations. And also for us, when, because of Section 29A, the old promoter or the old management team cannot be there. So before we go acquire a company, we have to put in place a management team.
True.
So even if it is a good company with bad balance sheet, we can't work with the old management of that company. This allows us to keep the company out of IBC and work with the promoter and the existing management team to fix it. So because we use trust but verify, meaning we'll put the controls in that even a promoter that may have not done the right things, in the past would potentially do the right things if you're watching the cookie jar.
I think as a lawyer, Nishant, you are going by the rule of the book, saying that, okay, RBI has certain power and it sort of bodes well for it to stay within that. But from a business perspective, I think I understand where Ravi is coming from. I think what RBI did in terms of the IBC was a more practical solution. And now with what Supreme Court has done, it's kind of going back in time.
Frankly, I don't know how practical is FEP12 circular is, because many people have found many problems with the FEP12 circular from a practical point of view, right? You need 100% creditors approval. You have only 180 days. It just one size fit all approach, which doesn't actually work. So from a policy perspective, if you were to look at the market conditions, does that actually work? People have various viewpoint just from how the deals are made, just how the resolution plans are constructed. There are many big cases actually where operational creditors have gone to IBC and the lenders have resisting going to IBC, right? Because they felt this is not the right resolution process, and if they really want to get the maximization of value, they should actually avoid going to the IBC.
Now, I want to sort of talk about specifics. So what happens to the Jet case now?
To me, it's like a moving target and I'm not a good shot.
As far as Jet is concerned, this is the first case where they have invoked the power and utilized project Sashak. I think they are trying to find a resolution outside IBC, and lenders have converted their loan into equity. They perhaps may find a solution, better solution, if operational creditors are actually supporting it, because operational creditors may not benefit at all if it goes into IBC. So there are many commercial drivers in a specific distressed asset to figure out what is the best solution.
We've seen what happened to Kingfisher, right?
Yeah.
And globally, airlines, the way they work is it's a marketing company. Right. So they don't own the planes, they lease the planes.
Right.
They don't own the landing slots, they pay a lease for it, although they kind of have it in the sense that it's allocated to them, or the schedules, if you will. So at the end of the day, there is no liquidation value of an airline except its brand, and potentially the only thing of value is their frequent flyer miles, right? So therefore, the lenders are probably very amenable to not use IBC, and they would be very happy to just use Shashak to restructure this company, and potentially why the old promoter was hanging on till the last minute, because he knew that it's if I'm not there, it's the abyss, right, for the lenders. So who's going to run this thing? Who's going to come in? And for whatever reason, the acquiring company, Etihad, their partner, they also have said, they're not really keen, notwithstanding, what would happen to this airline, whether they can manage it without Mr. Goyal or not. I have no idea.
Prepack arrangements, will they be back? What does it mean for that now?
So the market has been doing synthetic prepacks by acquiring these loans. The investors are acquiring these loans through an ARC or whichever mechanism that they were able to use, and then restructuring it out of court. So a prepack, so when you take a company as an investor and say, listen, I'm interested in buying it at X price, and you put it and you go to the lenders and you say, listen, I want to clean it up, I'm going to put it in bankruptcy. Even if you own the loans, there is an auction process. So somebody else can come in and pay 1 rupee more than your price, and they will own the company. And there is no concept of stalking horse bid in this country yet in IBC. So that means that I've done all the work, and I say, the value of this company is 100, and somebody says, because 8 Capital is such a smart investor, I'm willing to pay 130 because they'll at least make 2x out of this. So from my perspective, if I am not willing to match the 130 or go beyond, I lose all the time I've spent on it, but then also my returns come down. However, in a prepack, I negotiate with all the stakeholders, not just the lenders. I negotiate with, potentially the labor, the trade creditors, the statutory liabilities, and even if the promoter, the nuisance value, keeping Section 29A in mind, I'm not really sure whether in a prepack a Section 29A comes on or not. I've not thought about it that much, but I would assume so because it is IBC. So I go in and there is no other bidder who can come in because it's a prepack. The judge, it's basically you go in, you come out. It's like a kiss, right? You're done, okay? So that's what is so attractive about it. And considering...
It's attractive, you think that will stay on?
Absolutely. I mean, if a prepack comes on, we will definitely use it.
Okay, so now what happens to the earlier cases like SR, electricity? Do we actually see them going back to NCLT to sort of claim their companies? Can that really happen with this?
I don't think so. The way Supreme Court has clarified that position, the first 12 cases were very specific references, and the subsequent batch of cases were very specific references. They were internal deliberation, due care, as the Supreme Court is laying down. So I don't think so. Those cases will have a basis on the basis of Supreme Court ruling to say that this is void under law.
So, like 1 minute concluding remarks from each of you. Where do we go from here? What will we sort of be watching out for?
I think there will be more directional clarity from Reserve Bank of India, and it will bode well positively for the market.
Well, I think that whenever RBI comes out, we'll find out more. That's the uncertainty bit, by the way. In the meantime, the lenders are going to figure out if a resolution can be done with using ICA. And if the bids are attractive enough, they will sell the loans. And ultimately, they might still use NCLT for situations where they feel they need to do so. But I think if wherever they needed to do that, they've already done it. Okay. So in a way, the horses have already left the barn. And this is largely for the power assets.
Okay, I come to my rapid fire. We had the conclusion remarks from both of you. I'll begin with you, Nishant. What's the first thing that comes to your mind when I say the following? The jet resolution.
It's very uncertain.
Supreme Court judgment on Feb 12 circular.
I think it provides clear direction to the market.
IBC.
It's a game changer. It's there to stay.
Okay, the most overhyped transaction and the dirty dozen, according to you?
I won't be able to comment on it because we're involved in many of those cases.
Suppose you are in an elevator with the finance minister, suppose today, and you were to give like a 2-minute advice to him, what would that be?
I think as far as certain sectors are concerned, government needs to come up with some resolution which will definitely help. For example, power. RBI as a regulator won't be able to actually help the power companies.
I come to you now, Ravi. The first question that will come to your mind if you are if you bump into the finance minister in the elevator.
So actually, I have had that occasion. I was in Oberoi and I met Chidambaram when he was the finance minister, and I said to him, "You look much better in person." But seriously, I would say that we need to have a framework where things like prepack, are accelerated because, RBI is the one controlling how many banking licenses are there, so the finance ministry cannot get involved in it. But certainly they can take the uncertainty away from the taxation angle of many of these things to make for example, the net operating loss of a company that we are acquiring. It's with change of control, you don't get that. So the old losses of the company, which has significant amount of value to an acquirer because I don't have to pay tax for a long time till I cover those losses, go away automatically.
And what comes to you when I say the following? Willful defaulter.
I think that's one of the best things that is there in this whole framework is the aspect of willful defaulter, because it's been so ingrained in the system, it needed to be yanked out, and Section 29A did that.
Nirav Modi.
I'm glad I don't like diamonds.
I think with that we'll sort of conclude this episode of Deal Street. Till the time we see you next. See us. Goodbye and good luck. Thank you.